My name is Bage Jugona Nganga, currently the chairperson of the Kenya Law Reform Commission. I have been a practicing advocate for the last 34 years, basically in private practice, lastly a senior partner of the firm of Waluhiu Koad and Nganga Advocates. I have previously been a commissioner of the Kenya Law Reform Commission since 2003. I have also served as the chairman of the Energy Tribunal, which is a tribunal with a mandate of adjudication of disputes within the energy sector. I was appointed chairperson of the Kenya Law Reform Commission substantively and sworn into office on 17th of January 2014. The Kenya Law Reform Commission, as presently constituted, is a body established by the Kenya Law Reform Commission Act of 2013. This commission is the successor to the Kenya Law Reform Commission, originally established under the Kenya Law Reform Commission Act of 1982. The Kenya Law Reform Commission of 1982 was a department of the Attorney General's office for many years. It served as a technical arm assisting the Office of the Attorney General in keeping the laws of Kenya under constant review, with a view of reforming them and consolidating them to ensure that they are in accordance with the socio-economic conditions of Kenya. In 2003, when the NARC government came into power, the government was reconstituted such that a new Ministry of Justice and Constitutional Affairs was created. The Kenya Law Reform Commission was transferred to be a department of the Ministry of Justice and Constitutional Affairs. The creation of the Ministry of Justice and Constitutional Affairs was intended by the NARC government to be the lead ministry in development of constitutional reform. Constitutional reform was one of the main agenda of the NARC government. And in the role given by the ministry, Kenya Law Reform Commission was seen as a very important organ in helping driving the reform process. This became more so, especially after the 2007 post-election violence. After the signing of the National and Reconciliation Accord, key areas were identified of reforming the Kenyan society. There were issues about equity, land matters, and inclusiveness in the political process. And it was seen that it was necessary that all these matters will be addressed in the new proposed constitutional development process. So the Kenya Law Reform Commission was seen as a very important agency in the creation of the legal framework required to champion this constitutional reform process. The Commission was, alongside other state agencies, involved in developing the legislative framework that was necessary to move the reform agenda forward. It drafted the constitutional amendments that established the Committee of Experts. It prepared the legislation that established the Interim Independent Elections and Boundaries Commission, the Truth, Justice and Reconciliation Commission. The commission continued being involved in the constitutional reform process up to the promulgation of the Constitution of Kenya 2010 on 27th August 2010. The sixth schedule of the Constitution gave the Commission the constitutional mandate to work alongside the Office of the Attorney General and the Commission of Implementation of the Constitution in preparing the necessary legislation to be tabled in Parliament to implement the Constitution. Given this enhanced constitutional mandate, it became necessary to restructure and strengthen the Commission. The Kenya Law Reform Commission Act of 2013 reiterated the constitutional mandate of the Kenya Law Reform Commission in working with the Office of the Attorney General and the Constitutional Implementation Commission to prepare and table in Parliament any legislation that is outstanding and required to implement the Constitution. It also gave mandate to the Kenya Law Reform Commission to assist the county governments in developing their legislation and reforming the same. It further reiterated the traditional mandate of the Kenya Law Reform Commission of ensuring a review, reform, and consolidation of the laws of Kenya. The Kenya Law Reform Commission therefore acts as a policy link between the policy-making process and the legislative process. It works with the Office of the Attorney General, the Commission of Implementation of the Constitution, and other relevant government agencies in ensuring that the legislation required to implement the Constitution and reform the statute law is in place. After their being sworn into office, the commissioners found it necessary to undergo some form of induction for them to be able to internalize the mandate of the commission. So between 4th and 7th of March, the commission held a retreat which was facilitated by the Constitutional Implementation Commission. And during this retreat, various facilitators made presentations to the commissioners, breaking down the mandate of the commission and clearly making the commissioners understand the enormous mandate that has been reposed to the commission. After undertaking that retreat, the commission now decides it is necessary to undertake a public launch of the commission where other stakeholders will be invited so that the commission can sensitize the country and the public of the mandate of the commission and how all state and non-state actors can work with the commission to fulfill the enormous mandate of the commission to faithfully ensure that the laws of Kenya are reformed with a view of making them simple, clear, just, equitable, and accessible to all Kenyans.
My name is Doreen Mothaura. I'm the Vice Chairperson, Kenya Law Reform Commission. I'm a trained legislative drafter and an advocate of the High Court of Kenya. Previously, before joining the Commission, I was working with the Office of the Attorney General and the Commission for the Implementation of the Constitution, still dealing with matters of legislative drafting and law reform issues. Before the The Commission is established under law, an Act of Parliament 2013, number 19, which came into force early in 2013. That particular law did bring with it, set out the mandate of the Commission. Under Section 5, the Act actually gives the Commission powers, auxiliary and incidental, to carry out its functions. So it is enabled by the law to undertake its functions. And those functions are later on enumerated under Section 6, which brings about the core business of the Commission. There are other acts that have given this Commission responsibilities and mandates, but in this case I would like to focus on what the Kenya Law Reform Commission Act as requires of the Commission. One is to carry out the traditional mandate of law reforms the world over, which is to keep under review all books, all acts under the statute book. So another issue is to make sure that there is consistency. The laws are harmonized, just, simple, and accessible, modernized, and cost-effective in its implementation. I think this is a critical issue that the Law Reform Commission ought to do, and this is a mandate given by the law. The others is, of course, in light of the enactment of the Constitution, which has set out very progressive values and principles. The Commission is required to ensure that the same reflects in the entire statute book. So this can be achieved through amendments to the existing book, to the statute book, or new laws that will bring about these values and principles. Because they are constitutional, they are mandatory. The other critical function is to undertake research and comparative studies, not necessarily just blotting the statute book with laws that cannot be enforced. So there has to be a realistic approach towards law reform. We are required, under the law requires that the Commission undertake collaborations, consultation in its generation of these laws, again in line with the policies and vision of the country. We have Vision 2030 and other pillars that the Commission is supposed to work towards through law, assisting both levels of government in coming up with laws that respond and geared towards that direction. There are other functions which are mandatory that the Commission ought to assist at the two levels of government, and specifically the counties, in generation of laws that are required to implement, to give effect to their mandate under the Constitution and also the statutes. We also have the aspect of legislative drafting. This Commission apparently is supposed to generate laws on its own motion without necessarily being requested by others. Where we carry out a study and identify gaps, we can come up with the legislative proposals, draft bills. Then in that case, the Commission has an hands-on drafting responsibility, in addition to matters of legal advice and with regard to reform matters.
My name is Apollo Mboya. I'm a commissioner with the Law Reform Commission. Previously, I worked in the Office of the Attorney General in the Department of Treaties and Agreements. As a part-time commissioner, I'm also a secretary of the Law Society of Kenya. The County Government Act 2012 requires the Commission to assist the 47 counties in coming up with legislation and policies regarding their functions that are itemized in the 4th schedule of the Constitution of Kenya. And in that respect, the Commission has come up with model laws that can be used by these counties to customize their legislation that suits their circumstances. And in that respect, about 20 county governments have contacted the Commission to assist with coming up with various legislation for their counties. In performance of its function, the Commission is required to inculcate public participation in its processes. And in that respect, coming up with the legislation involves the participation of other stakeholders, sensitization of the public on the required legislation, and also giving effect to some of the recommendations that have come up from the public. And in that respect, the Commission normally conducts meetings in various counties to get the views of the members of the public in order to come up with the legislation and policies that give effect and also the aspiration of the communities. As we are aware, Article 2, Sub-Article 5 of the Constitution says that the treaties that Kenya is party to are also part of our laws. And in that respect, the Commission is to ensure the domestication of those aspects of the treaties into our domestic legislation, and in that regard, the Commission has been in the forefront with regard to integration issues in the East African community, and has participated in the approximation of laws within the community to ensure that the common market protocol is fully operationalized within Kenya. And also, the Commission ensures that through the approximation of the laws in the region, that the laws in the East African community is harmonized with other partner states. The common market ensures that all the partner states in the East African community have cross-border transaction, cross-border relationship, cross-border movement and free movement of services and goods. With regard to the legal practitioners, this will enhance the free movement of labor and services, including cross-border legal practice.
Actually, the Commission is required to offer advice with matters of relating to law reform and identify areas that whichever level of government should address. You can only do this by doing an impact assessment or undertaking a research or a study regarding a situation and how best to address it. As we all know, it is not every other issue that requires a law. So there is need to advise also in terms of what policies can be generated. So the Commission, as a key player in matters of law reform and legislative process generally, it plays a critical role. It has a responsibility prior and even after the law has been enacted. So it can conduct both pre-legislation analysis or audit and post, and then advise the government on areas that require amendment or review. So this Commission is mandated to do that, and this can only be achieved by working closely hand in hand with the state corporations, state agencies, both levels of government, and also even the people of Kenya can advise on areas that require some assessment to be carried out. This in end, it will assist the government or the state to save in terms of in areas that would have been legislated on, which necessarily did not require as such. And as we know, after the promulgation of the Constitution, there were a flurry of laws that were enacted. So the Commission, undertaking its function of advising both levels of government, there is a need to commence an audit of existing laws to see whether actually all of them are necessary or which areas can be, amendments can be made to save the economy, to save the state and also to address the issue of cost-effective and reflective, realistic law reform in the country. So regulatory impact assessment, as is generally understood within the realm of law reform, is carrying out an audit, a study, an analysis of the benefits vis-a-vis the cost of implementing a law or even generating one to begin with. You know, every law that is enacted creates a framework to implement it, and this could have a cost on the mwananchi. So for before and after the law is done, there is need to carry out some study. And as a law reform commission, you can, from the word reform in itself, it tells you there's that aspect of both pre and post the law has been done. Before we initiate, or any government initiates a legislative issue, agenda, it needs to carry out some form of a study analysis, which may be in form of a policy or in form of an analysis, a study, just generally, to show where we are and where we intend to go and the cost implication of the same. This commission ought to be put on board or to be brought on board as the ministries or other, both the levels are engaging in that activity. They need to engage the commission because of the fact that we work with all the state organs and levels of government, and we are in a better position because we are able to know which statute book provides for what, and working with our other partners, we are able to assist in that process.
My name is Njoki Kahiga, a commissioner with the Kenya Law Reform. I am a human resource development expert who, prior to joining the commission, was a career civil servant who rose through the ranks to become an acting permanent secretary with the former Ministry of State for Public Service. The Commission played a very, very critical role in the implementation of the National Accord by being one of the core agencies that helped with the preparation of the agenda for registrations. During this period, the Commission participated in the preparation of the draft bills which were enacted as the Truth and Reconciliation Act, the Constitution of Kenya Review Act, which provided the legal framework for the establishment of the Committee of Experts who drafted the new constitution. The Commission also participated in drafting the Constitution of Kenya Amendment Act, which amended the Constitution and established the Interim Independent Electoral Commission, the Interim Independent Boundaries Review Commission, and the Interim Independent Constitutional Dispute Resolution Court, and the National Cohesion and Integration Act. The National Integration Act has been integrated into the laws of this country, and it is hoped that it will be enshrined in all future laws so that we avoid what happened in 2007. Ethnic and other diversities has been recognized in our constitution. The Kenya Law Reform Commission has the responsibility of ensuring that these principles are taken into consideration when we are reviewing and reforming the laws for purposes of ensuring that the country never goes back to the violence of 2007-2008.
Welcome to the Kenya Law Reform Commission. My name is Joash Dache. I'm the Commission Secretary and Chief Executive Officer. I'm a lawyer by profession, an advocate of the High Court of Kenya. I'm also a legislative drafter and a certified public secretary. The Commission has many stakeholders, but our primary stakeholder are the people of the Republic of Kenya. Beyond the people of Kenya, there are institutions that we must work closely with. Parliament of the Republic of Kenya, both the National Assembly and the Senate, and county assemblies. The national, executive, and the executive at the county level. We also work very closely with the judiciary, work very closely with professional organizations, the Law Society of Kenya, Federation of Women Lawyers, ICJ Kenya, APSEA, that is the Association of Professional Societies in Eastern Africa, APSEA. We also work very closely with the private sector, particularly KEPSA, Kenya Association of Manufacturers, and the others. We also work very closely with the non-state actors, particularly the NGOs, civil society groups. Again, we must not forget that we work very closely with our development partners. Other than those, we have constitutional commissions and independent offices. CIC, of course, comes to mind, and then the Office of the Controller of Budget, and the Office of the Auditor General, Office of the Director of Public Prosecutions as our key stakeholders that we must involve in our work and discharging our mandate as a Law Reform Commission. How do we work as a Law Reform Commission? There are two types of work that we do. One is constitutional implementation. There's a procedure around implementation of the Constitution. Basically, what happens with constitutional implementation bills, we get drafting instructions or road draft bills from ministries, departments, and agencies. We then translate those into legislative texts, which we then forward to the Attorney General and CIC. CIC does its own internal review. From there, CIC convenes what we call a roundtable. In the roundtable, you'll find a representative of the Law Reform Commission. You'll find a representative of the Attorney General. You'll find a representative of the CIC and a representative of the ministry, department, or agency which originated the bill. This is where the final consensus on the contents of bills is arrived at. From there, the bill is transmitted to the Attorney General for finalization. before it is taken for cabinet approval, then transmitted to offices of the Speaker of the Senate or the National Assembly for processing based on the standing orders of Parliament. How are we able to deliver on this in terms of our organizational structure? The Commission has 7 commissioners. You have a chairperson, vice chairperson, then you have 1 full-time commissioner, and then 4 part-time commissioners, 7 commissioners. This is the policy-making organ of the Constitution. It provides oversight and direction to the Secretariat. So whatever we do as a Secretariat must be run by them for purposes of oversight and even clearance. Whatever the Secretariat does has to be run by them because they constitute what is the Kenya Law Reform Commission. Other than the commissioners, we have the Secretariat that I head as the CEO. The Secretariat has both legal staff and other support staff. Currently, we are about 9 lawyers, that includes me, and the rest are support services. You know, accounts, human resource, procurement, records, library, etc., which contribute to the mandate of the Commission. The commissioners, headed by the chairperson and 6 other commissioners. Incidentally, for the first time, one of our commissioners is a lawyer because this idea that reform of the law is the function of only lawyers does not hold much water. Most of the public or the people that we deal with are not lawyers. So we have a representative of Wanjiku in the commission. We have a triple mandate, that is constitutional implementation, review of legislation, and assistance to county governments. In terms of review of legislation, the Commission may get a reference from any ministry, department, or agency, and most notably, the Attorney General. Again, the Commission may generate proposals on its own motion. In law, we say suo motu, on its own motion, probably from topical issues that we pick currently prevailing in the country. What do we do with the reference once we get it? First, we determine its agency, whether it's very urgent. Again, we determine whether we have the resources. Resources include both financial and human resources. If we're able to take up the reference, we'll definitely revert to the person who gave us the reference and tell them that we'll be able to undertake this exercise. If we are not able, we'll also revert and explain why we cannot do it at this particular time. Once we have accepted the reference is referred to a committee of the Commission, headed by a commissioner and assisted by members of the technical, 1 or 2 members of the technical team. This is what we call the implementation committee. The committee then develops its own terms of reference. If there's need to involve other stakeholders, they'll set up, they'll invite other stakeholders to be members of the committee. So it's this committee to develop its own terms of reference, its own work plan, and even budget cost, because you cannot reform the law without factoring in the issue of cost. This committee also engages stakeholders. You remember public participation is a constitutional principle. So it is this committee that must also engage with stakeholders. They receive memorandum and review them. The committee also develops what we call discussion papers, issues papers, basically for stakeholder engagement. Eventually, the committee may also do what we call comparative studies. This can be done online or physically visiting respective jurisdictions where some of these legal issues have been tackled before. The committee then prepares report, and normally this report is accompanied by a draft bill, which is then approved by the whole commission before we transmit it to the instructing ministry, department, or agency. We intend to follow this procedure, particularly when we are harmonizing over 700 pieces of existing law with the Constitution. And this is going to be a mammoth exercise by the Commission, very long term. For example, the South African Law Reform Commission has been undertaking harmonization of the law of South Africa with their 1996 Constitution. We are aware, they told us last year, they have only done a third of this exercise. It is quite capital intensive. It requires closer consultation with stakeholders, and we intend to use this procedure when we are harmonizing all existing law with the Constitution of Kenya 2010.
Hello Kenyans, my name is Ruth Kirwa. I'm a part-time commissioner at the Kenya Law Reform Commission. I'm also an advocate by training, and I'm able to represent the various academic interests from various universities in the Commission. The Commission is a key player as well as a stakeholder in ensuring that negotiations, preparation of East African Community legal instruments and legislation are done. It has also been central in ensuring that the Common Market Protocol and any amendments to the treaty are done, as well as ensuring that the treaties and any laws emanating from the East African Community actually are in conformity with Article 2, subsection 5, and Article 2, subsection 6 of the Constitution.
Thank you.
My name is Linda Musiribi Morella.